Hello, everyone. Thank you for sticking around. You are not going to regret it. This is the last panel of the day, and we've had an incredible day. I really want to thank you for sticking around. I hope you will ask questions during this panel. I'm going to be moderating. I'm going to be looking over in the chat, looking over in the questions, trying to get as much as I can from you all to make this as interactive as possible. You've been an incredible audience. There are hundreds and hundreds of you, and we couldn't be more thrilled. So we leave this panel for the end of the day, cyber insurance, and we've done that for the last 2 or 3 years because it turns out to be one of the more popular panels because it's the basis of everything. And I listened to some of the other panels and this had come up. It's just changing so much. You know, I teach this course at Duke, of cybersecurity and incident response, and I find that it's very hard for me to keep up on all the law and everything that's changing. So that's the goal today, to really give you a level of expertise in cyber insurance that will make you much, much smarter about it once you've left here. And we'll also introduce you to 3 very, very important people in the space. Starting first, this is something different. We've had no other panelists like this before, is Shruti Engstrom from Aon Insurance. And so what happens when you call your insurance broker, not the carrier, your broker, and you're in a panic about a cyber attack? Well, if you're lucky enough to have an Aon product and you call our next speaker, Shruti Engstrom, Senior Vice President for Aon's Cybersolutions E&O Cyber Claims Team, servicing Aon's clients nationally at Aon Insurance Company Services, you will get something very, very different. She is a trusted advocate and counselor for clients in the insurance claims process for cyber, technology, media, and professional liability exposures, meaning she will come in and evaluate your claim and help you figure out how to get paid by the insurance carrier. She collaborates with clients and the Cybersolutions team to address these complex issues throughout the insurance lifecycle, from pre-placement discussions through post-claim negotiations. And you got to give some credit to Aon here, because Shruti is the real deal, having worked an entire career as an insurance lawyer, including 10 years at Reed Smith, working with clients to resolve commercial general liability, product liability, first-party property insurance, business interruption insurance. And this makes her not just a problem solver, but also a sanctuary provider amid the chaos and the confusion and the panic of a data security incident. So her theme song, I think it's Count on Me by Bruno Mars, because like 1, 2, 3, she'll be there when you need her. So welcome, Shruti, to your first conference. It's been great getting to know you, and I really look forward to hearing your views and having you share them with everyone. So welcome.
Thanks, John. Happy to be here.
Excellent. And next up is my good friend Scott Goddess at Barnes and Thornburg, and he is the James Bond of cyber insurance battles. You will see from Scott's bio that he's co-chair of Barnes and Thornburg's Data Security and Privacy and Insurance Recovery and Counseling Groups, where he's helped insurers recover more than $1 billion in claims. I don't know any other lawyer with this combo of leadership responsibilities. It's really quite something. Scott has been a mainstay participant in all of our master classes because there's really no lawyer on the planet who understands cyber insurance policies better. And what you won't see from his bio is that for insurers who decide not to pay, Scott has perfected his cyber insurance practice into an art, almost a Zen-like form. It's not just that he's filed 2 landmark appeals on behalf of insured against insurance companies who deny charges, both in the 11th Circuit on behalf of the insured after a data security incident. One he won and the other settled, which means, you know, in my view, he won both. But it's also that Scott handled these cases from start to finish. He didn't pass the case along to one of his appellant specialist colleagues. He just did it himself. And another thing that Scott does, and I've worked a lot with him on this, is to take a look at a cyber insurance policy and tell you what's great about it and tell you what stinks about it and tell you what endorsements are needed. And that is absolutely critical. It has to be reviewed every year because, again, insurance policies change so much and whether they're going to pay. I would say if Scott had a theme song, it would be Mama Said Knock You Out by LL Cool J, because that's what happens when anyone crosses Scott. They get knocked out. Welcome, Scott Goddess.
Don't call it a comeback, John. It's nice to be back.
And next up is not Dave Fontaine, who we were supposed to have. Dave Fontaine is sitting in a witness room in an unnamed state, waiting to be called to testify in a matter that he's working on for one of his portfolio companies. So I heard from Dave this morning, and we decided, okay, well, what are we going to do? Well, let's find one of the aces. We happen to have like 30 of them talking today. One of them is bound to be available. And our first call, Jennifer Beckage, who I already introduced to you, is a spectacular data breach response lawyer, has her own firm, is a technologist, is an incredibly courageous woman. You heard me talk about her before. Now she gets to be on the panel with me. So this is just great. She had done a Twitter space with me on cyber insurance and cyber. So I knew she was familiar with this outline. So I think we're very lucky here that we can figure out, we can get all these different angles, because Jennifer actually gets hired by a lot of insurance companies. She's one of their favorites in terms of getting hired and on insurance panels for data breach response work. So Jennifer, thanks for stepping in. Are you prepared?
I'm prepared.
Outstanding.
I'm a lawyer. I'm used to a hot bench, so bring it on, John.
All right. Well, and I should say your firm, I think this morning I said Beckage LLC. It's the Beckage firm, right? Tell me what it's called.
Sir. The Beckage firm. Yep, we're a boutique women and veteran-owned data security and privacy law firm.
I love it. And when did you start your firm?
A few years ago. As you mentioned earlier, I had a cancer battle, so I actually started my own firm a number of years ago, took a break to address my health, and back stronger and better than ever.
Yeah, that is absolutely true. So you're an inspiration for the lawyers out there, for the entrepreneurs out there, and just for people who have had to deal and overcome incredibly difficult challenges. So let's get into this cyber insurance. So the way we're doing this is we're going to start out with a lightning round. And the first question that I want to put out there is, I was listening to the CISO panel and I was reading the chat, and I saw a lot of people were saying, well, can a CISO get insurance? What is a CISO supposed to do? What about the other employees at the company? How does that work? I'm going to start with Scott, then I'll go to Shruti, then I'll go to Jen, and give me your comments. And the benefit you get with Shruti is not just that she works for a brokerage, a genuine insurance brokerage, but she was also a lawyer, an insurance lawyer before that. So it's kind of good to talk to someone who has both sides of it and is experiencing this argument sort of this issue in real time. So Scott, go. What do you think? What do you tell people?
So you look at and you think about cyber insurance for the issue overall. And then if the CISO is thinking, what about me as an individual? What about government agencies coming a calling or looking to me directly? Then you look at the D&O policy and think, is my title and is my role within the company one where the insurance company would agree that I'm an insured person, as it's usually used? And if there's questions about it, and you're in the company or the CISO's thinking about it at renewal time, it's worth asking, how will the insurance carrier treat me? And if I don't like the answer, can we do something to change that? Can I be listed in the policy? Can I be addressed directly? And that's not to say, oh, we're rolling over and saying they're not covered, but we're saying, what can we do to take the most aggressive steps and the best steps to deal how the insurance company views people, so that there are fewer questions that you don't need to call Shruti, you don't need to call me or somebody else to have the fight about it later.
Shruti, is that David Lashway in one of the panels was talking about how important it is to read your policy? And as I listened to him, I was like, I don't know that I could do that. I'd have to hire Scott or Jen or someone. I used to teach these policies, but I can't get through them anymore. It might be because of my old age. What do you think? How do you work through these processes?
So I think, the best thing you can do is partner with your broker. Hopefully you've got a good broker that is willing to sit down with you, talk you through your coverages, explain those to you. And to Scott's point, your broker should hopefully proactively be talking to you about this particular CISO issue in the D&O policy. And we certainly have a lot of clients that are asking questions and brokers that are having those discussions with their clients. To make sure they're either named in the policy, make sure the position is named in the policy, and if the client doesn't want to get that specific, make sure that they know whether or not the CISO is considered an officer under the company's bylaws. So There's a lot of discussions being had around it, but I do think go to your team of experts that you have, whether it is your lawyer or your broker, and start having those conversations. It's a good use of your time for sure.
Yeah. Jen, you're someone who a firm would love to hire as a CISO, so I know you can look at it from that perspective. What's your take on what are you telling your clients? Maybe are the clients looking out for their CISOs, or are the CISOs coming to you? How are you figuring out this issue?
Yeah, I mean, kind of as mentioned, it's not always very clear whether the CISO is going to be a covered officer or not. So asking these questions and working with your trusted advisors. And look, all CISOs and all executives right now, because of recent decisions and regulatory investigations, are more and more concerned about individual liability. They don't want to be seen as, negligent or grossly negligent in their activities. So, and sometimes, when we're called in as a breach coach to work on a matter, so an insurance carrier will hand us a case to work on. We're working for the company, and sometimes the company's interests may not be aligned with the CISO's interests. Right. There could be some conflicts there. You could have whistleblower situations. So there could be a lot of moving parts, but at the outset, at renewal, working with your broker and your trusted advisors to understand where everyone's protected. And as Scott said, what are your options if it's not?
Yeah, I mean, I saw somebody in the chat said CISO liability. CISO stands for Chief Information Scapegoat Officer. I hope we're not getting to that level, but I think that's how people have to think about it, because especially when the regulators have an expectation, the SEC seems to have an expectation of the CISO like they would a board member or a CFO, and I don't know if that's fair.
I don't think it's fair. Working on incidents, it's not just a technical response. I mean, there's so many different parts of leadership that need to be involved. And so, that's just one piece of the puzzle is the technology side. And I'll say, having worked, for the last, 10, 15 years on incidents, all the companies I see, honestly, they're all just trying to do the right thing. The CISO's trying to do the right thing. When we see the headlines, that's usually the odd case, right? The one that, you really hope no one in your organization is acting like, and we hope that they're not, becoming more common. But again, preparation is key.
Well, let me ask this question. So one of the things I always tell clients when they want to do the risk and security assessments that we used to do at Strauss-Friedberg, and that I've worked a lot on some of them with Scott, you tell these, you want to make sure that some of these companies want to make these heat maps where they tell all the problems at the company, or they give you a big laundry list of all the potential issues that could come up and all the things that need to be fixed. And it always strikes me as that's the worst thing you could do for a client, because you're creating this roadmap, even for the insurance company, to deny your coverage because you've had all these problems. So let me bring that back to you, Jen, and then I'd like to hear from both Scott and Shruti about that. Is it a mistake to do these laundry lists? Because there's no way you're ever going to meet them. You're never going to have perfect cybersecurity. It's an oxymoron. And if you sit down and you're a CISO and you come in and you say, hey, these are 15 things that need to be fixed, and the board says, hey, there's only 2 things we're going to do, we can't afford to do the rest. What do you make of those kinds of things? Is that a bad practice that's going to hurt you during the claims process?
Well, you want to be honest in your application, right? That's what's going to hurt you in a claims process, is if you were dishonest. But no, I mean, you've got to assess risk and make that list. And, you've got to be careful what you're documenting, right? Is it a hypothetical? Is it a real risk? That's why risk assessments are really important. But, also make sure that you're involving everybody else in the determination of the risk. And that InfoSec has to work with legal, because it's not just, technology and standards and compliance, but there's also laws that they need to comply with as well. So I think we do need to document risks, and many times it's legally required, whether it's data security or data privacy related. But you got to take action if you do put it in writing. I always tell all the So there are teams that I'm working with. If you get a smelly report from a pen test or vulnerability assessment, you can't just shred it or put it away or we'll worry about it later. If you see the red flame, you got to act on the red flame that's on the report, and take those steps and actions. Otherwise, that's going to be Exhibit A from a plaintiff's lawyer. Look, they said they needed to do these things and they didn't.
What do you think, Shruti? Do you ever come across that sort of problem?
I don't, but I do think, from a coverage perspective, to Jennifer's point, first, you do have to tell the truth on your insurance application. I'm a big fan of counseling our clients to tell the truth about what they have, talk about what they're planning on doing with their insurance companies so that they're presenting, their story and how they're looking at their risks. And supplementing their applications if they need to. And again, to her point about the stinky report, if you put it away in the drawer, you could be faced with a situation down the road where your insurance company says to me, well, this is almost an expected loss, right? Like you knew this loss could occur. So you have to do the right things when it comes to risk assessments. But then you also have to make sure you're executing, telling your insurance company what you're doing, and making the changes that you need to make.
Mm-hmm. Scott, you want to add to that?
Of course. So, John, you hit on the point of what happens in terms of the insurance carrier having the information, and Shruti and Jen were talking about it. Everyone will say, of course, be honest, answer the question exactly as it's asking. Give information that you understand to be truthful, but be mindful that there are lots of, and Shruti reminds me, there are lots of good claims that are handled appropriately or appropriately enough. But there are a lot of claims where the carriers look at the documentation as to what's out there, the heat map or otherwise, or information provided, and say, well, you say you do X, but you didn't do it this time. You say you do Y, you didn't do it this time. Or you said that this is the system you have, these are the steps that you take. You didn't do it. Well, now we're going to rescind the policy because it was a misrepresentation in the application. And carriers will tell you, their lawyers will tell you, if they pick New York law, they love to say that New York does not have an intent requirement for rescission. Now, again, it's an arguable point. Yes. Are there other things that go along with it? Yes. But they'll say there is not a question of what was your mindset. It was a question of, was it accurate or was it not, is what their lawyers will say. It's just not a place where a policyholder wants to be, is arguing, is that the standard, and arguing, did I give the correct information? And was your question understandable? Was your question unambiguous? And did we answer it appropriately? That's happening more and more often.
Yeah, strict liability for a misrepresentation on your questionnaire.
Or an unknowing answer. Right.
That's brutal. Here's a question from the chat. Whether the board agrees to take actions advised by the CISO, as long as the advice is documented, that should cover the CISO's potential liability. What do you think, panel? Is that good enough?
Well, the ultimate question is never, is it good enough? It's a question of whether a regulator or a claimant thinks it is or is not, and then you're defending against it. Right. And there's an old joke that a liability insurance policy is really litigation insurance designed to give you defense cost coverage. And so if it costs you a lot of money to defend it, and at the end of the day, you were exonerated and you don't have liability, how much money was spent to defend? And so if a person's concerned, are they going to be indemnified by the company? Okay. If they're concerned that perhaps they won't be indemnified or there won't be enough money to do it, how does the insurance apply is a question that is coming up more and more often.
Yeah. Shruti, let me ask you this, and then I want to hear Jen as well. What's the mistake you see companies most often make during the cyber insurance application or renewal process? What do you see as the most common mistake? And then I want to hear Jen as well.
So I see two mistakes. One is something that Jen alluded to earlier. It's a failure within the organization to have their risk team and their legal team and their InfoSec team all talk and get on the same page. Sometimes you've got people answering questions that shouldn't be answering them on the applications. Sometimes you've got people doing things on one side of the house that the people answering the questions don't know about. So I think a failure to communicate within your organization is definitely one of the mistakes I've seen. And I'm kind of blanking now on the second mistake that I've seen. Oh, I know what it is. It's Scott said this. Those insurance application questions are not always very clear. They're just not. They're vague. And so you can answer the question one way thinking you know what it means, when in fact, the insurance company may interpret it somewhat differently. So, I think just because you might have like 2 lines to answer your question doesn't mean your answer only needs to fit in those 2 lines. So if you've got an explanation or a supplement or something more to add or a caveat, do it. Because the application questions they're not very clear, in my opinion.
Jen, what do you think?
Yeah, and I love, your comment about, you can add more, you can add description. If you have to check no for multi-factor authentication, but you have other compensating controls, describe those. But again, if you don't have the right team answering this questionnaire that's going to live with you for a while, that's important. And I think it's a really good time to sort of round up. If you're a CISO of an organization, you're obviously trying to keep the organization's, information secure. You've got employees to worry about. You got to make sure that we've got enough controls in place to get cybersecurity insurance, right? We got to have enough to be in a legally defensible position. We got to satisfy all of the laws, that we're facing. Oh, there's this contract that's requiring us to do something else. This is a lot, right? Oh, and if we have an incident, I'm the incident response lead. There's a lot of moving parts with this. And sometimes I see CISOs or organizations have a misguided belief on what they should be working on. And I'll give you an example that I usually give is, I was working with a CISO at an organization, and he was his number one priority was working on a clean desk policy. And they weren't subject to HIPAA. They didn't need to worry about that based on the laws that applied to them. They didn't, really even handle personal information at all. I mean, there's just like a lot of things that made like, who's that trusted advisor that you're listening to tell you what you should focus on? Because what you should maybe focusing your money and dollars and time is on something else that will get you a strong policy. That's a great risk mitigation strategy. So I think getting, as everyone's mentioned on this call, everyone in the same room is good, not just to answer truthful questions to the questionnaire, but what's our overall security posture and strategy and goals with that?
Hey, Scott, here's a quick question. Thanks, Jen. Here's a quick question from someone in the chat. Is there a better, more company-friendly governing law choice that doesn't have New York's potentially strict liability standards? And will the insurance companies accept the change to that provision? So here puts you on the spot.
Yep. No, I think that's a great question. The question of precision and the question of policy interpretation is a state law driven question. And so then there are states that are seen as more policyholder friendly, whether it be the availability of bad faith, if you think that you would be locked into your choice of law for bad faith, as well as contract interpretation, as well as rescission. So there are states that have requirements in terms of intentional conduct, a state of mind. And there also are states where the law is more policyholder friendly, or at least even handed in terms of interpreting the insurance policy, because it's not just the question of precision, but it's also how is the contract interpreted. And New York law is chosen quite often by insurance companies. And so query as a buyer, why does the insurance company want New York law? Why don't they want Washington state law or California or Delaware, where so many companies are incorporated? Why do they pick New York? I'll leave it to the conversation between the underwriter and the broker and the buyer to say, why do you love New York law so much? And see if you can drill down into the answer there. And I know the answer, and I know why they pick it.
Awesome. Hey, Shruti, tell me this. What is the smartest thing you've ever seen a company do with respect to their cyber insurance, where you've gotten involved and you've thought, wow, this company did something right, and it's lucky they did this? Am I putting you on the spot too much to think of something like that?
No. Well, I think the smartest thing is really sitting down and thinking about your risk posture. in connection with your insurance policy. Because, again, but that means you've got the whole team, not just the risk manager or, the director of insurance buying the policy. So to me, that's the smartest thing. You're thinking about your risk posture. You're thinking about where your losses are possibly going to add up, what you really need in your insurance policy. You're thinking about choice of law. You're thinking about if your network is down, do you need 365 days as your period of restoration, or are you going to be okay with 90 days? You're never going to be okay with 90 days. So really having that thoughtful discussion with your stakeholders and then buying your insurance accordingly. And I think the other smart thing to do is have a really good broker partner. It really matters that your broker understands these issues for you and talks to you about them and walks you through the process.
John, if I can jump in, because that's all perfect advice. And I would say the third point is ultimately, if you can get a copy of the policy at the time of renewal as you're talking about what's being offered. Because what ends up happening is companies tend to renew policies all at the same time, and they get an overview from their carrier saying, we're willing to underwrite you at this premium with these limits. And maybe they list the names of the endorsements. There's no policy form provided. There's no endorsements provided.
Right.
And so how can somebody evaluate what's a contract, the carriers will always say, without the terms of the contract? And particularly carriers update and adjust their policy language fairly regularly. So a third best practice, in addition to what Shruti said, is ask the underwriter through the broker to get a copy of what is being proposed with the actual terms, as opposed to just 3 pages of titles.
Yeah, one of the things I've seen you do, Scott, is get these endorsements. And for those of you who don't know what an endorsement is, it's just an amendment. Correct me if I'm wrong, Scott, but just an amendment to a policy, an addendum. They call them endorsements. As far as sometimes you can get them for free, right? You can just tell somebody, hey, these are some endorsements we'd like to get added. Jennifer, did you ever have an experience like that? How do you navigate all these various endorsements when you're trying to figure out what's best for your clients?
Yeah, I mean, I agree. You got to work with a strong broker that knows cyber, because it's really hard when we're working with carriers and we get an insured or a client comes to us directly, and the broker that they've been working with didn't understand technology and cyber, didn't know they were processing credit cards, didn't know that they were subject to certain laws, and then they really don't have anything. And of course, the buying company, the insured, thought they had all of this. I got quote cyber, right? Cyber means I get everything, right? So that's always heartbreaking when they thought that they were paying for something and they just didn't understand it. So, I think it's a team effort, as we all said. The other thing, as far as, reviewing endorsements and all of that, is, to think about what the legal requirements are, and what you have to have based on your business practices. And those might change over time through merger and acquisition, or, the excitement with AI, new development and tools, right? It's not always a one and done. You may need to reassess things as you go through. But the other thing that I often see is that, and maybe sometimes it's because the CFO is buying cyber and the CISO isn't, or isn't part of the conversation, but the CISO, in preparing for an incident, has on retainer incident response firms, printing companies for notification letters, public relations companies. And I love the preparedness, right? But the truth of the matter is, if you have cyber insurance, when you're assigned a breach coach law firm, they will be the ones to engage a lot of those parties to try to cover everything under privilege. So you've now been spending a lot of money in retainers, right? That may not be an approved provider. So this is, again, a great time to talk with your carrier broker. Like, I really want to use this entity. This is who I work with. Can I get them approved in advance? But it's always upsetting when I see them spending money on services that are already going to be covered by cyber. They could have put that money into another tool, right? Or another piece of compliance. So look, John, you're not the only person who doesn't want to pour over insurance policies. Right? I remember when I went to law school, but the first one I read, I was like, I'll never be doing anything related to this. And now I'm in this industry. My whole life is insurance policies every day. I understand that people don't want to look at it, but it's really, really important from a risk mitigation standpoint.
Yeah, I think, like I said, I think it's become such a special skill. It's just hard for your general practitioner to do it. Hey Scott, this is something that Jen's comments kind of brought to mind. So on one of the breaches that I worked on and cyber attacks I worked on, the adjuster calls up. The adjuster hires a law firm, and I look at the law firm name, and it's like this big time litigation law firm. And I get the client gets the questionnaire, or I'm sorry, it looks like a discovery. It looks like a discovery request, and that's what it might as well be one. It's 20 pages. It's like, give me every communication about the data accident. Give me all your cybersecurity penetration testing. Give me all the reports you've had on this. So and it's the lawyer at this litigation firm who's asking for this information, working with the adjuster. The client turns to me and says, it's going to cost me at least $250,000 to $500,000 to even respond to this. And so they start responding. Is that something, what's the story with that? And how do you combat that? And what happens, is that a good practice that for carriers to do? Is that what they do often? And then I want to hear Shruti's opinion on that as well.
Man, I can't buckle up for the next hour on Goddess on privilege and carrier claim adjusting practices.
Okay.
So not to take a whole hour, but that's happening much more frequently. There's a law firm that has an entire practice doing just this. There are law firms that have departments doing just this.
Right.
Carriers outsource claim handling to law firms more and more regularly. Question why? If the insurance policy is easily understood with language that the reasonable person can understand, why do they need a lawyer to handle the claim? Particularly when the claim adjusters at the insurance carriers are almost always former lawyers when it comes to cyber insurance. And then your question goes to, what do you do? Well, if the person handling the claim is outside counsel and they are introducing an extraordinarily aggressive reservation of rights, now making it so that the policyholder and the carrier are at issue, then query whether they have the right to information when they've made a potential conflict of interest. And a plaintiff lawyer worth her or his salt will say, I want discovery of all of those communications. And then you're in the spot saying, well, of course we're aligned. And if the carrier is taking this position that you're not, or they're looking for information in an effort to deny or limit or rescind coverage, where do you land on privilege? Now everyone's lost, right? Because if those communications have to get turned over, then it obviously harms the policyholder. And if the carrier was supposed to be covering, it harms the carrier as well. So there are some lawyers that handle these things in an even-handed fashion. And yet the tell comes down to, if there's a coverage dispute and coverage litigation, what does the insurance carrier say about communications with the outside law firm? Are they discoverable because it was claim handling in the ordinary course of business? Or is it privileged? And if it's privileged or it's work product, that means they thought that they were at issue and in dispute with the policyholder and used a lawyer that had the carrier's interest there rather than the policyholder's interest at the same level. So it's a very common and a very teeth gnashing event when you're trying to figure out what can I give and what can I provide while wanting to be certain that everyone's on the same page and aligned and protective of the policyholder's interests.
So you could probably make the argument, hey, this insurance company you probably made this argument. This insurance company was never going to pay in the first place because they hired this litigation firm to bombard my client with requests from the moment it started. And if they go, no, we were just helping adjust the claim, then you could say, well, hand over all the discovery since it's not hand over all your notes from every single meeting because it's not in anticipation of litigation. It's not covered by a privilege. You're just another person's.
You've obviously read the things I filed in court.
Yeah, have you done
exactly right. If they denied for minute one, how is that handling it in good faith? If they did not deny, then everything is supposed to be discoverable.
Yeah.
And as a practice pointer, if you're under New York law, one of the things New York law is fantastic of saying an attorney handling claims is typically not having communications that are seen as privileged as to the policyholder when it comes to discovery.
Excellent. Shruti, do you have anything to add to that but from your insights on the brokerage side? So it's really disturbing for clients. And then I want to hear if Jen has had a similar experience. Go ahead.
I have to say, I'm only been with Aon for 2 years. It was extremely disturbing for me too when I first joined. Now I will come in some defense of some of these firms. There are many firms that are handling this in a pretty even-handed way. I think, frankly, some of the reasons that they're hired is because the claims handlers don't actually have the capacity to do all of the work that needs to be done by themselves. So they need some help. So, but to that end, I totally agree with Scott on the privilege issue. That was literally one of the first cases I litigated when I was a baby lawyer. And we got all of the communications. They were not considered privileged. So we really caution our clients on what type of information they're sharing. Let's be very judicious and thoughtful about the information we're sharing. I'm also a big proponent of sharing information by phone, frankly. We don't necessarily need to, have written discovery responses to all of these questions. And look, the carrier is always going to ask more questions than they actually need answers to. So when you have a discussion with them, we can rein it in. You don't have to answer every single question. You do have to cooperate, right? You have to give them the information they need to investigate the claim and make the coverage determination. But it doesn't have to be everything under the sun. So there is a thoughtful, process that you can engage in to help avoid some of those issues.
Jennifer, how do you handle that's great, Shruti. Thank you. Jennifer, how do you handle an aggressive adjuster who hires a law firm out there? Is that stuff even covered when your client says, look, I'm trying to deal with this response and I just got this discovery request, this questionnaire masquerading, or I don't know how to put it, but the bottom line is I got a very onerous request from the insurance company and I don't even know if it's covered and it's going to suck up all the resources of our response.
Yeah. I mean, again, you got to imagine this situation of it. There's a data breach going on, right? We don't know what's going to happen with the organization. There's a lot of stress and tensions, and insurance ends up being a really difficult piece of this puzzle that people don't want to have conversations about, but they're so important at the outset. It raises a lot of flags. The insured at the end of the day needs to think about, who's representing them, who's really representing their best interests, and being careful about, sharing. I think they all have that gut instinct reaction when these situations occur, to be cautious about, what they might share, not to be disingenuous, not to do it in bad faith, but they just want to understand everyone's role in everything. And it can be very cloudy. At the outset of an incident, you're dealing maybe with your day-to-day IT, you're also dealing with external forensics, you've got a law firm breach coach involved, your broker's on the line, you've got a claims rep, maybe an attorney. There's a lot of people wearing a lot of different hats and asking questions and understanding, your posture. We don't get in the middle of coverage disputes that the insured has with their carrier. We represent them in the incident and, providing information, to the carrier and coordinating, the response team. But obviously lots of issues pop up along the way.
I mean, I like to make it a separate work stream with respect to documentation for the insurance company and essentially a separate reporting work stream where the team working on it is very focused on it, is updated on everything, updating the insurance company. What are your best practices, Jen, when it comes to trying to get paid?
Yeah, when we're on panel, we're working for a carrier, we're doing a lot of, communications and trying to be, really high touch. Obviously you got to think about, do I need to share privileged information with a carrier, right? They don't need to have a lot, if any, privileged information when you're working on an incident, but there's decisions that are going to need to be made where the carrier is going to have enough information to be able to do that and understand the risk and understand, well, if we do that, are we going to save money in business, loss costs, or, or is a ransomware going to exceed this? So we're always weighing those, all those different options with the insured, but again, being cautious about what's being shared with them. But you want to have a good relationship with your adjuster. Right. You want to have a great relationship with your carrier. You want to, you don't want to be right. The worst thing you could do is be one of the lawyers there, right? Like, you can't talk to my client and you can't do anything. No, you want to, we all are trying to work together to solve a problem.
Yeah, that's very important. I think, Scott, when we're talking about these questionnaires, so let's be clear about this. When you get your cyber insurance policy, one of the things that I think is so good about it, it's sort of like if you're going to get a health insurance policy, you've got to go to the doctor first and get a physical to find out what shape you're in. And you can't be lying on your physical. If you've got some terrible disease or some kind of ailment or something that runs in your family, you've got to be candid about that. Otherwise, you might not get your coverage. So the same goes. That's why the cyber insurance process can be a good one, right? Because you can suddenly learn all kinds of things about you. It's a healthy process to go into. But it seems to me that you're likely to say things in this application that are not true. Probably by accident. We talked about how New York has this strict liability or lack of intent type of approach to it. How do you manage a situation when you see that the insurance company has asked for information and you realize that, hey, this client, their application wasn't completely true, just like 99% of the applications I've ever looked at? Or maybe I'm being too aggressive. What do you think?
So then what ends up happening is the carrier starts asking questions. And if, for those of us who have been doing this for a while, you can tell where they're going with it. That they're not asking the questions to figure out how do I resolve the event. They're not asking questions to figure out how to present the best defense to a class action. They're not asking questions to figure out how can I best respond to the regulator, or what do I do about paying the ransom. They're asking questions that are designed to say, here's why you fall into this exclusion. Here's why we could rescind. Here's why you could do these things. And then it's stepping back and saying and figuring out, what are they asking? Let's answer the question. Let's do it both truthfully, but also being mindful of where do we stand. And if they're asking questions that have disaligned the parties, what can we do about it? And being mindful the entire time that the adjuster will be insistent getting the information. They will put into so many communications. If you don't answer this, you're violating your duty to cooperate and you breach the policy. That's quite a legal conclusion. And I don't read the duty to cooperate as saying we have to hand everything to you that helps you deny or rescind coverage. But you can work with them and taking a light touch and figuring it out, and also figuring out what was said in the application, what do the questions say, and it does take a very careful walk down that line, and then candidly talking with the broker and seeing if the broker understands what's happening. Is this an adjuster who is super aggressive? Why are they doing it? How do they view things? And see what the broker has to say, and if they have any inside information. But that is probably the least comfortable place to be as a policyholder when, as Jen said, you're trying to deal with the event. It's undoubtedly all hands on deck situation. And then a carrier starting to ask questions that is just designed to help them take back the money they paid or not pay money out and leave you without insurance. And so you're in a terrible situation that is made worse. And so again, it's just one of the least comfortable situations in the cyber claim process.
Yeah, excellent. Shruti, this has to do, I want to ask you a question from the broker's perspective about active war and terrorism provisions that have obviously been litigated back and forth for a while. The Secretary of Defense says, hey, this ransomware attack was an act of terror. And all of a sudden, does that trigger the denial of coverage because of those provisions? What are you seeing the carriers do? And what should people do to make sure that they're covered as best as they can be? What are the limits? Every cyber attack could be defined as an act of terror. I teach this to my class, and I think it gets very difficult when you read these provisions and then you see the judges poring over them. How do you view it from the brokerage perspective when you're trying to provide the best policy for people, but also when you're seeing the carriers really question whether this should get payment, like a big pipeline attack, like the one that happened in North Carolina?
Well, so I will tell you, we have not seen carriers really invoke the war exclusion in the last few years, and honestly, we've got multiple wars happening right now in the world. Mm-hmm. So I think that carriers are actually being pretty cautious about invoking the war exclusion. Now, there have been revisions to the war exclusion. I think the London market was pretty aggressive with their revisions. I think they hurt their business by being aggressive with the revisions. So I think some of it's being dialed back. But look, the fact of the matter is the war exclusion in the cyber world, I don't think has been litigated. Scott, tell me if I'm wrong, but I don't think it has been.
It's in the first party property world, but then it created all the cyber insurers to
that's
insert
right.
new exclusions.
Right. That was first party property. That was not cyber. So, I think it's an unknown. I think that is a highly, highly, highly factual issue. So I think that carriers are and should be very careful about throwing the war exclusion around. And I think once you start throwing the war exclusion around, it really calls into question the value of this product. So I think the insurance companies are aware of that.
Excellent.
So I don't think that they're being really aggressive with it yet.
Okay, I want to cover two last topics. I want to go to Scott, then I want to go to Jen. I want to go to Scott and ask you, you've written a lot about silent cyber. And that was something maybe 2 or 3 years ago, which obviously is like decades ago in cyber years. But I want you to comment on that for everyone, because I think Shruti just kind of touched on that a little bit. And then I want to ask Jen about ransomware attacks, whether the cyber insurer is part of the negotiations and how you work that out. And then I think we're going to run out of time. So we've got a couple minutes left. I'd like to cover those two. So go ahead, Scott.
Silent cyber is the idea that policies that are not marketed as quote unquote cyber insurance can provide coverage for cyber-based risks. The industry has said that they need to do a better job of eliminating quote unquote silent cyber, putting in exclusions or saying explicitly where they are or they are not covering. There are policy changes to come around, but there are still policies being sold that are without the exciting exclusion. So the Insurance Services Office wrote a form back in 2014 for general liability policies about data breaches. Many CGL policies include them. Some do not, even those are sold recently. There are other policies where there are opportunities. There are other policies that have pockets of coverage. So when there's a situation where there perhaps is not enough coverage under the cyber program, or for those companies that don't have it, it is worth asking. And I continue to get carriers that even who write cyber insurance say, hey, have you notified these other carriers? One circumstance where there was a business email compromise, I call up the cyber carrier and said, hey, let's talk about it. They said, we really think it's a professional liability insurance question. I said, oh, interesting. I call a professional liability carrier and he said, we really think this is a cyber insurance question. So silent cyber may have been addressed a little bit better, but it is still, for better or for worse, alive and well.
Yeah, it's great. If you've got Scott on your side and you make an argument and you're an insurance carrier and he's heard it before, man, you are just in not a good place. Jen, let's go to you. So I'm fascinated also by the ransomware negotiation process. And I think it's interesting, just a couple of years ago when OFAC reissued their guidance about potential liability, I think they specifically mentioned insurance carriers and certainly said at certain conferences, including some of our own, that, hey, these insurance carriers could be found liable in the process or could be found responsible. That's criminally responsible if you end up paying someone that the ransom who happens to be a terrorist. How involved is the insurance company in the actual payment process? I mean, aren't they worried that this might be just some kind of scam between the insured and the ransomware attacker? And remember, we don't know who the ransomware attacker is, so it's a poltergeist. So how often do you see the insurance company involved, and how do you manage that?
Yeah, great question. I mean, typical lawyer answer, it depends on the situation. So first of all, an insured or a company shouldn't try to do any communications with a threat actor on their own.
Right.
They want to work with someone who has experience doing it. So they can go to their breach coach, like our firm would provide data as far as, this threat actor group usually doesn't provide, a help, or, they won't honor their promises, or they'll negotiate a number here. So there's lots of data that's had. So sometimes the insurance companies will have their own internal teams that will help evaluate, if we're going to pay ransom and how and to whom. Sometimes, the insured, hopefully they don't, but they might reach out on their own. Still, the carrier would be involved. But typically that's coordinated through the breach coach. Sometimes a third party is brought in to help, facilitate those communications. But we got to think about OFAC. We got to think about law enforcement. There's a lot of things to think about because there could be fines and penalties. It's not just like, we'll just pay and everything's going to be okay now. There could be, down the line, some liability there. So insurance companies, I find, have been very helpful, ask good questions, have a good dialogue concerning all of it. We really honestly haven't seen a lot of problems. I think a lot of things we talked about today, some of it is just, the rare situation. Some things are a little bit more common than others, but yeah, insurance companies are involved in the ransomware payment process.
Excellent. All right. Well, I see Bruce has shown up, so I know the clock on the wall is ticking. I want to thank Scott. I want to thank Shruti. This has been incredible. Jen, thanks for coming in and taking Dave Fontaine's place. You were perfect. Wonderful. Bruce, I have to say this in all honesty. This was the best panel of the entire day. So I don't say that with, I really, it's just clear. I really enjoyed it. I think this insurance panel, all three of these people need to be spoken to by anyone who's got kind of issues in the insurance area, because it's part of every single other panel. So thanks to you, Bruce, for an incredible day. Again, Scott, Shruti, and Jennifer, thanks for doing a fantastic job. Just jam-packed, and we really appreciate the audience as well. I didn't get to everybody's questions, but I got to some of them. And Bruce, you just did an amazing job today putting together a cast of spectacular superstars, and look forward to seeing some of this on YouTube once you get it up there for everybody. And just thanks to you for doing this.
Well, thanks for saying that, John. And Jen, Scott, and Shruti, thank you so much. And John Stark, thank you for moderating the panel.
Oh yeah.
Thank you for being an incomparable MC all day long, and for being an invaluable partner just in organizing today's event from start to finish. So thank you, John.
You're welcome, my brother.
Let me just quickly acknowledge our friends from FGS Global, FTI, John Reed Star Consulting, Kroll, and Stone Turn, great corporate sponsors of this event, and we really appreciate it. And of course, the 24 world-class law firms that were represented here today as sponsors and supporters of the event. Thank you. Thank you all for being with us today for this virtual event. That is the last panel. Please stick around for just a few more minutes. We're going to be back to announce our Incident Response 50 for the year 2024. That's our list of the best lawyers in the field. We will be right back.